Hi, my name is Lauren Hickman, and I decided to do my showcase on student discipline and due process. What is the issue? After talking to some individuals from my school system, I found that a current issue occurring at our school is making sure administrators are trained to know that students have due process rights. In essence, the administrators need to do a better job of giving students the opportunity to give their side of the story when they are accused of a wrongdoing. In past months, it's been said that situations have arisen where due process was not given to students or it was not done in the correct way. The school system is working towards providing more trainers to administrators that will teach them the importance of providing students their due process rights and how to provide their due process rights. What does the law say? There are four major Supreme Court cases that address student due process rights. Goss v. Lopez, 1975, Ingram v. Wright, 1977, Board of Curators of the University of Missouri v. Horowitz, 1978, and Bethel School District v. Frazier, 1986. Goss v. Lopez, 1975. According to the facts of this case, 9 students were suspended 10 days from high schools in Ohio. The principals did not provide students with hearings before the suspensions, and Ohio law did not require it. The Supreme Court ruled that students who are expelled even for a short period of time must be given minimum due process. Our book noted further on this case, stating that recognizing that a student's state-created property right to an education is protected by the 14th Amendment, the court ruled that such a right cannot be impaired unless a student is afforded notice of the charges and an opportunity to refute them before an impartial decision maker. According to the court, students suspended should be given notice and a hearing at a minimum. The second case relating to this issue is Ingram v. Wright, 1977. According to the facts of this case, 2 boys, including Ingram, received corporal punishment from their principals, and the boys claimed that they were deprived of their constitutional rights. Our book noted further on this case, saying that the use of corporal punishment in public schools does not violate the 8th Amendment's prohibition against the government's infliction of cruel and unusual punishment or the 14th Amendment's procedural due process guarantees. In regards to due process, the ruling means that students do not have the right to receive notice or a hearing before receiving corporal punishment. So in essence, if their administrators decided to give corporal punishment, they'll usually have a slip. Like at our school, we have a slip that they'll sign on their agenda, and this is just saying that they don't have to go through a whole process like they would if they're given a suspension to do this. The third case relating to this issue is the Board of Curators of the University of Missouri v. Horowitz, 1978. According to the facts of this case, a student named Charlotte Horowitz was dismissed from her university due to low performance in clinicals. A council had reviewed her academic standing prior to the dismissal and warned if her performance did not improve, she would not graduate and she would face expulsion. So according to this case, Horowitz did not improve, so she sued, claiming that the procedure leading to her dismissal violated the due process clause of the 14th Amendment. The court concluded that the procedures leading up to her dismissal did not violate her 14th Amendment rights and that a hearing in front of a decision-making body was not required in dismissals involving academic deficiencies. The fourth case related to this issue is the Bethel School District v. Frazier, 1986. And even though this is a big case on students' First Amendment rights, it also kind of covered a little bit about the 14th Amendment's rights as well. So according to the facts of this case, Matthew Frazier made a lewd comment in front of 600 students during a campaign speech, and Frazier was suspended for 2 days following the incident. In one of Frazier's claims, he claimed his 14th Amendment rights were violated because he did not know his speech would lead him to disciplinary sanctions. So in regards to due process, the Supreme Court ruled that given the school's need to be able to impose disciplinary sanctions for a wide range of unanticipated conduct disruptive of the educational process, the school disciplinary rules need not be as detailed as a criminal code, which imposes criminal sanctions. 2-day suspension from school does not rise to the level of a penal sanction, calling for the full panoply of procedural due process protections applicable to a criminal prosecution. The school's disciplinary rule prescribing obscene language and the pre-speech admonitions of teachers gave adequate warning to Frazier that his lewd speech could subject him to sanctions. So, what is required for due process? So, according to Goss versus Lopez, it's not constitutionally required to provide students with cancel and cross-examination. And Bethel School District versus Frazier added to this by saying 2-day suspensions do not rise to the degree of full due process that occurs in criminal prosecution. So basically, this is just saying that you don't have to give them like a full court trial like they do in criminal cases. In Goss versus Lopez, the court ruled that due process afforded to students is an informal process, and the disciplinarian may discuss the misconduct with the student's minutes after it occurs. In Goss versus Lopez, it also mentioned that when unusual situations arise, some more formal procedures should occur. And they didn't really go into detail about what these formal procedures should include, but they just said basically the crime should fit the punishment pretty much. They noted that the disciplinarian should include more extensive processes when factual disputes occur or there are arguments over cause and effect. Two of the other cases, the Board of Curators of the University of Missouri versus Horowitz and Ingram versus Wright, noted these informal hearings are not required to administer corporal punishment or to dismiss students due to academic reasons. So how does this relate to the school issue? Currently in my district, they're trying to reiterate the importance of providing due process to students when they are accused of a wrongdoing. So principals are needing more training on remembering to give due process to students and how to provide due process to students. The Supreme Court cases that have been discussed help to establish due process rights for students. Students who are being disciplined with suspension or expulsion must be given an informal opportunity to be read their charges and to give their account of what occurred. When more extensive punishments are given, the hearing must be more formal. Due process is not required for corporal punishment or for academic dismissals. It is the information in these court cases that will be reiterated in the trainings to our principals. And basically, they're just trying to reiterate that students need to be heard because that's part of their rights. And if you have a situation that's like this where you don't give them the chance to tell you what happened, they may come in and something happened, like something was in their book bag or something, and it just was placed there on accident. And then you just kind of want to listen to their side of the story before you give an extreme punishment to them. And then the last page is references.